Imagine opening your bank account during a divorce and realizing $15,000 is suddenly gone. Then you discover your spouse bought a brand new car in cash. The business account that had $50,000 last month now only has $12,000 left. And the credit card statements? Expensive dinners, hotel stays, luxury purchases, and random cash withdrawals you never approved. At that point, most people ask the same question. Can I legally stop my spouse from spending money during the divorce? The answer is yes, but you have to move quickly because the court won't automatically step in unless action is taken. One of the most stressful parts of divorce is watching marital money disappear in real time. And unfortunately, it happens more often than people think. Some spouses start draining accounts out of anger. Others try to hide money before property division. And sometimes people simply believe they can spend whatever they want before the divorce is finalized. But under Florida law, there are legal tools that can help protect marital assets while the divorce is ongoing. The key is understanding two things. First, what counts as improper spending? And second, how to get court intervention before the money is gone. What Florida law says: Florida courts take dissipation of marital assets very seriously. Dissipation basically means intentionally wasting, hiding, depleting, or destroying marital money or property before the divorce is finalized. And judges absolutely consider this when dividing assets. For example, if your spouse wastes $40,000 during the divorce, the judge may compensate you by giving you a larger share of the remaining assets later. But here's the important part. That does not automatically stop the spending while it's happening. Which means if your spouse is actively draining accounts, you may need emergency court orders immediately. What the court can do. Florida courts can issue temporary orders restricting financial activity during divorce proceedings. Depending on the situation, the court can freeze bank accounts, restrict large withdrawals, limit credit card use, require approval for large purchases, order detailed financial accountings, prevent assets from being sold or transferred. And in severe cases, the court can even appoint a receiver, someone who temporarily manages marital assets to prevent further damage. If there's an emergency, your attorney can request an expedited hearing and ask the judge to intervene quickly, sometimes within days. What counts as wasteful spending? Now, not all spending is considered dissipation. The court understands that life still continues during divorce. People still need to pay the mortgage, buy groceries, cover children's expenses, pay utilities, maintain vehicles, handle reasonable legal and medical expenses. That's normal. What raises red flags is spending that appears reckless, secretive, or intended to reduce the amount of money available for division. Examples include gambling away marital funds, buying expensive gifts for a new romantic partner, taking lavish solo vacations, transferring money to friends or family, making large unexplained cash withdrawals, selling assets below market value, draining business accounts without explanation. The court looks at one main question. Is this spending consistent with the couple's normal lifestyle? Or is someone trying to intentionally deplete marital assets? How to prove it? And this is where evidence becomes critical. Courts do not freeze accounts based on assumptions or accusations alone. You need documentation. That means collecting bank statements, credit card statements, screenshots of transactions, photos of expensive purchases, social media posts showing lavish spending, before and after account balances, witness testimony if applicable. The more organized and specific your evidence is, the stronger your request for emergency relief becomes. Because from the court's perspective, details matter. Saying, "I think my spouse is hiding money," is not enough. Showing multiple unexplained withdrawals, transfers, or suspicious purchases, that's very different. How fast can you act? Timing matters more than people realize. If your spouse is actively draining accounts right now, waiting weeks can make recovery much harder. In emergency situations, your attorney can file motions asking the court to freeze accounts immediately, stop certain transactions, prevent property sales, restrict spending temporarily. And once the judge issues an order, violating it can lead to serious consequences. That includes contempt of court, fines, paying the other spouse's attorney fees, or even receiving a smaller share of marital assets later. Before filing for divorce. A lot of people also ask, what if I haven't filed for divorce yet? You still have options. Before filing, many people document all account balances, save copies of financial records, close joint credit cards, separate direct deposits, monitor transactions closely. In some situations, spouses may withdraw half of joint funds and place them into a separate account temporarily. But you have to be careful. Trying to hide money yourself or taking more than your fair share can absolutely backfire in court. The biggest mistake people make is waiting too long and hoping the situation improves on its own. Because once assets disappear, recovering them becomes much harder. So if you believe your spouse is draining accounts, hiding money, or wasting marital assets during a Florida divorce, document everything, act quickly, and speak with an experienced divorce attorney immediately. If you need help protecting your financial future during a divorce, contact Nest Law today.